All right, here's a good one. So today we're going to get into how to write an offer. So we're going to go step by step on how to write an offer to purchase if you're working with a buyer that want to make an offer on a property. So we're going to go line by line. Here we're going to use the MAR form. We're going to use MAR form 501. You folks all should have access to it. So let's get into it. All right, so the first thing we have here is the buyers and the sellers, right? So for the buyers, yes, you want to put the buyer's information there, their name, their address. And then for the sellers, you can, put their information in. Now, some agents, they just choose to say owner of record. I don't like that. I would actually go into public records and see who the actual owners are and write their names in there, okay? You can find this, either go to masslandrecords.com, look up the deed, or just go in the MLS, go to tools, hit public records, type in the property address. It'll tell you who the owner of records are. All right, so the next line here is the agent. And here's where you want to put your information. So you're going to write your name. For me, it'll be Louis Garcia. And what I also like to include here is I put dash and I put eXp Realty. So whatever brokerage you're with, I would write your name, dash, and then put your brokerage. There is another spot, again, where you can add the brokerage info. I just like doing that for extra protection, but that's up to you. In theory, you can just use your name, but if you add the brokerage info, it's not a bad thing to do as well. And then you're going to choose, well, how are you representing your client? Are you a buyer's agent, seller's agent, facilitator? What are you? So you want to check that off. In this case, I'm going to make believe I'm a buyer's agent. I'm going to check off buyer agent because that's typically how you're going to be doing this. And then we'll move on to the next line. And on the next line, it's going to read on behalf of, and this is where you're going to put the buyer's name. So your client's information is going to go here. If it's 2 people, 3 people, if it's a trust or an entity, write the name of the trust or the entity, but then dash, put the name of the person that has the right to make decisions, right? Whoever the executor is, whoever that person is that has the right, put that, dash and that person's there. You're going to add that right on that line. Now, this provision, that you see under here just says that you still have to do the mandatory disclosure form, even though you're stating here in writing that you are behaving as a certain type of agent, you still have to do the Massachusetts mandatory relationship disclosure form. That's required by law. If you haven't seen that video, there'll be a link here. You can watch that video on how to fill that out. So next we have what is the property the buyer is going to be purchasing. So here we're going to put in the property address or whatever information that we have for the address. We're going to note it here. Now sometimes agents will add the square footage of it. If you like to do that, that's fine. If there's an address, usually the address is okay. If you want to get a little bit deeper and add the book and page from the Registry of Deeds, that's okay. You can add that information here. Now, the next line, it says, which has been introduced. Now, this is where you are going to add your brokerage information. So for me, this is where I'll add eXp Realty. So it's saying, the buyers are making an offer to buy this particular property. They were introduced to this property by eXp Realty because I'm the agent for eXp. I'm listed above, but the brokerage is eXp Realty. Because remember, all the contracts, even though that you're an agent and you're out there working with folks, your brokerage actually, you're doing business on your brokerage behalf. They own those contracts. They those clients belong to them. So you have to put that in there as far as that, on behalf of whatever brokerage, you're going to add that information on that line. All right, so now we're going to get into what are they offering, and this is where you're going to have a discussion with your buyers as far as what do you want to offer on the property. So here you would put in the offer price. Let's just say that the offer is going to be $500,000, and that's what I would put here. So I would type in $500,000. It's going to be on that first line. Then under that, you're going to see what is the initial deposit. Again, you're going to talk to your client and see what are they comfortable giving. Obviously, in a market like this, the higher your initial deposit, the stronger the offer is. Let's just say that our client here is going to offer, the typical you see $1,000. So we'll put $1,000 in this line. But again, it could be whatever the client is comfortable offering. Now, next is going to be, how is that $1,000 going to be delivered? How is that deposit going to be delivered? Is it going to be immediately with the offer, or is it upon an accepted offer? Now, I always choose upon accepted offer. If the seller moves forward with us, we will give you the deposit check typically within 24 to 48 hours. And you want to use that timeline. You want that deposit check as soon as possible, because remember that the purpose of that check is to bind the agreement. If you have an offer and you don't give the deposit check and a week goes by, or you decide to do home inspection and not give the deposit check, technically the seller can move on to a different offer because there was nothing to bind this contract because you didn't give the deposit check. So you want to make sure you give it to them as soon as possible. Once that offer's been signed by the sellers, you make arrangements with that agent to either overnight it, hand deliver it, whatever it is, or the clients drop it off, but you want to do that within 24 to 48 hours. Now, the next line under double I, this is going to be, well, how much is going to be given at P&S, at the purchase and sales agreement? So, this is, again, is another conversation with your client. What are you comfortable doing? Some agents will recommend, well, listen, whatever your total deposit is, if it's 3.5%, 5%, you should put that there. Sometimes the buyers may have it, sometimes they may not, right? They might have to pull money out of a 401k or something like that, and that might take some time. So we have to see what they have liquid in order to put down. So have a conversation there. Let's just say, for the example here, I'm going to say that my clients are going to put $10,000 down. So really they're giving $11,000 total. We'll get into the financing. We'll say they're putting 5% down on this deal. We'll do 10,000 at P&S and we'll do 1,000 for the deposit. Now, number 2, duration of this offer. Now, you should always have a date and time in here. You should never have an open-ended contract. That's not good for your buyer. And also you can use this to negotiate, right? So this is where I've used this where if, let's say it's a Friday, they're going to do an open house on Sunday. I'll make an offer on Friday and say, listen, this is going to terminate Saturday at noontime or Saturday at 8 o'clock, right? So, because I don't want you to do that open house. I want you to move, on this offer here. So you can use this kind of strategically to your benefit if you use it right? Sometimes it works, sometimes it doesn't, depending on the market. But you always want to have a termination date here. And I would also talk to the listing agent, right? Because especially if a lot of times the agents, you'll see a disclosure saying like, look, offers are going to be reviewed on this date at this time. But that means reviewed. Doesn't mean that they're going to make a decision at that date and time. So what you want to, is talk to the agent, say, listen, I know you have it, let's say, Monday at 5 o'clock and it's the weekend. When do you think the seller's going to make a decision? Because if I put the termination of Monday at 5 o'clock, when that listing agent sits down with the seller, well, guess what? The offer expired. It's really not there anymore, right? So you want to give that window. You want to add at least another couple of hours or maybe into the next day. So that way it gives time for the seller to actually review it and then sign the document. So number 3 is going to be the purchase and sales agreement on when the P&S is going to be drafted and dated by all parties. Now, usually, here's the rule of thumb, right? Is that if you're doing a 30-day closing, typically it's within 10 to 14 days after the accepted offer is when the P&S will get done, right? But you can talk to the parties, you can talk to, it all depends are the buyers waiving home inspection? Because then at that point, you can do the P&S sooner. Are there some delays where maybe home inspection has to be pushed out? Are you closing in 45 days instead of 30? So you have to kind of play with that. But rule of thumb is typically 10 to 14 days after this offer has been signed is when you'll do the purchase and sales. So let's just say it's Monday, the first of whatever the month you have, go out 2 weeks, right? So by, either day 10, between 10 or 14, choose a date that's good for your buyer, add it in there, and that's when the P&S should be done, where all parties are going to sign off, and your buyer is going to give that initial, that second deposit. So make sure that they'll have their funds available for that date because they're going to be looking for that when they sign the P&S. Number 4 is going to be the closing. So yeah, have a conversation, figure out when you want to close. That's good for your buyer, 30 days, 45 days. Also talk to the lender. Because you may say, yeah, they want to close in 30 days, but, depending on the program that they have, 30 days may not be long enough, right? The lender might need more time, especially if they're using any type of grant program, or if they're using, USDA rural housing. You can't do that in 30 days. That's a minimum of 45 days. If they're doing a 2 or 3K rehab, that's going to take longer too. So talk to your lender, have an idea of what's going to be an appropriate closing date. Also, talk to the listing agent. See what the sellers are looking for. They're looking to move, close sooner or later, or maybe, you might grant them a use and occupancy. So have that conversation before you start putting dates in here to know, realistically what's going to be a good closing date for everyone. Now, in addition to that, you're going to put the county that the property's in. So whatever county that property is in, you want to make reference to that we're going to close at, at the registry of deeds of this particular county on this date at this time. Now, for closing dates, right? Another piece here is don't date it for 5 o'clock, on a Friday that you're going to close, because the registry is already closed. Okay. So what I do here is, and usually my rule of thumb is that I don't like closing on Fridays. I always choose a Thursday. So that way, if it has to be late Thursday, 5 o'clock by Thursday, if there's a delay, it'll get picked up on Friday, and then my people can still move in for the weekend. All right. If you choose Friday and, 5 o'clock and it doesn't close, guess what? Your buyers can't move in. Well, most likely they won't be able to move in. You'll have to ask for use and occupancy, but that's a whole nother mess, right? So if they want to guarantee that they're going to be the owners of the property, be able to move in for the weekend, I would date it for the Thursday. And it could be 5 o'clock, that's fine. If you do date it for Friday, date it for like 2 o'clock in the afternoon, the latest. So that way there's still a chance it can go on record. All right, number 5, the escrow money. Okay, so here typically you're going to put in wherever that check is being made out to. So if the listing agent, if their brokerage is holding the escrow money, you put the brokerage name there. If an attorney is holding the escrow money, then you put the attorney information there. Okay, and that'll be listed. Now, whatever you choose here, usually for that purchase and sales deposit, it's going to be the same place. Okay, so have a conversation with the listing agent. There are some brokers out there that don't like holding money, and they'll say, no, the seller's attorney is going to hold money. That's okay. Have a conversation with your buyers, let them know, get that information. So you make sure you write the check out to the attorney, and you're going to write that here. Now, in this paragraph, and you should be reading all of this. I know I'm kind of going through and helping you kind of fill out the blanks, but you should dive in and really, really read it so you have a full understanding of what the entire document is stating. So under this section here, it says that, yes, the escrow agent will hold the money and they're going to account for it and so forth. However, they will not release the money unless there's a mutual agreement. So if there's ever a problem in the deal, if the seller just feels that they're entitled to the money, it's not going to automatically go to them. Both parties have to mutually agree. So they'll both have to sign a release and the buyer says, yep, give the seller that $1,000. If the buyer says, no, I'm not agreeing to that, and they're fighting over it, the escrow agent has to remain neutral. They can't do anything until they either get it in writing or they get a court order. At that point, the judge or the magistrate will say, this is where the deposit's going to go. And then legally they have to do that. So understand that deposit could be in limbo a little bit if there is a dispute in the deal, that's going on. So that's what that item 5 here under escrow is going to pertain to. All right, so under 6, we start our contingencies that we have in the offer. Now, the first one we have is the mortgage contingency. So this is the first get out of jail free card that the buyer gets, all right? And with what we're stating here is that, listen, this offer is contingent on the buyer receiving financing. If they can't get financing, then we get to back out and we get a deposit back. Okay, so that's really what's happening here. Now, when you're filling this out on the first part here under the $, what I do to really make this easy, because different agents do this differently, right? So let's say, like in my example, we have the buyers buying this property at $500,000. They're putting 5% down. Okay, that means they're financing 95% loan to value, right? They're borrowing 95%. They're putting 5% down. If you do the math, 5% of 500,000 is 25,000. So that means they're borrowing 475,000. Now, some agents will actually write that in, 475,000, and then they'll put a dash and let you know what type of financing. Is it conventional? Is it FHA, right? Or cash, whatever it is. If it's conventional, I do a dash and I put CONV with a period, and they know it's conventional. If it's FHA, right? FHA, and we're good, right? Because you have to let them know how you're buying the property. What type of financing are you doing? That's part of your pre-approval letter as well. So instead of doing the math on everything, because here's what happens, right? So let's say, we negotiate and we have to go higher, right? So now it's 510. The purchase price ends up being 510. Well, now I got to calculate 5% out of 510. Now, an easier way to do this is, instead of putting the number, just write in the amount they're financing as far as percentage. So for instance, this is what I would do. I would write 95% LTV dash conventional. So what this means, it doesn't matter what the final sale price ends up being. The buyer's going to finance 95% of it, regardless of what the number is. It's very easy, right? So we're saying 95% LTV dash CONV. That's what I would do. But if you want to do the full number, listen, that's no problem. You can do that too, whatever you're comfortable with. This is just how I do it, but you can do it however you like. Now, the next line, this is important. This is your commitment letter date, okay? So what we're saying here is that, listen, we're going to make this offer. The bank is going to commit to let us borrow the money by this date. And now usually rule of thumb is 3 weeks from the accepted offer date, right? So if we're doing a 30-day, closing 4 weeks, it's week 3. The end of week 3 is when you'll do that. So, I kind of go backwards, whatever my closing date's going to be. I'll go back maybe 7 days, right? 5 to 7 days. And then I'll choose that. Remember, it has to be a business day. You can't use a weekend. So it has to be whatever that business day falls into, you put it in there. So we'll just say maybe, the 21st day or the 25th day of the month. If you're using number one, the day one is a Monday, right? We're going, 4 weeks that way. So just calculate it that way. Now it's important to be conscious of this date. Different attorneys have different styles. Right? Typically where I'm in Worcester County, we give this and the attorneys kind of take care of that, right? The lenders and the attorney, they keep an eye on the commitment date. And if we're not there yet, they'll send out an extension. Other attorneys say, no, that's not my job. That's the agent's job. All right. So what I do is put a calendar, reminder the day before of whatever date you have there on your calendar with the property address and all that info. So that way that, it pops up, that if you do have to grant an extent or ask for an extension, at least you have time, and then you can talk to the lender, request the extension, and then go from there. I'll go into extension paperwork on another video. Very easy to do, but there's different types of extensions that we have. Okay, so that's just something to do in good practice. Now on page 2, you're going to see this line here on the top. Now this is still part of the financing contingency. Now this is important. This here states that, the buyer has to make reasonable efforts to try to obtain financing, okay? Now, this date, you're going to put a date here, and typically this date is going to state by when will the buyer have to submit a full application. Now, understand this, the pre-approval or the pre-qual is not an application. It's a guess, right? The lender says, look, based on this information that I've verified, it looks like you're going to get approved for the loan, but we haven't started the process yet. Once you find a property and you have an offer that's been signed, send me a copy, and then we will start an application, a full application, okay? What I normally put here for the application is typically within 3 business days. So if, again, if the offer gets accepted on Monday, I'll put in by Thursday that the buyer has to submit a full application with whatever lender. Okay, and that will protect the buyer. So and also they know that they have a timeline. They have to get the application done within this time to protect their mortgage contingency. If they don't submit the application, if they do it after the fact, it doesn't protect their mortgage contingency because they're breach of contract at this point. Okay, so have a conversation with your with your buyers, talk to the lender, and make sure they'll be able to do that. But I typically do 3 days there. All right, so the second contingency we have is the home inspection contingency. This is the second get out of jail free card that the buyer has. Now, the buyer has the right to perform a home inspection if they choose to. The seller can never say, you cannot do a home inspection. That is illegal. They cannot do that. The buyer has a right to do that, okay? Now they have a window. They have a window that they can do it in, and it's usually within 10 days. So it's 10 days of when the offer gets signed. So when you present the offer, count 10 days. It doesn't have to be business days, 10 days, and then you're going to use that date. So yes, the end of the home inspection contingency and the P&S date's going to be very close together, but that's by design because usually after you're done with home inspection, if everything is good, then you're going to move forward, right? If it's not going to be good, then you're going to terminate the P&S and you're all set. So, and if there's some negotiations that's happened, then you're going to add that language to the purchase and sales. Now, understand this about home inspection, because some agents use this as, oh, this means that we have the right to negotiate. It does not. If you read the clause here, it states that the buyer has either they have the right to perform a home inspection. If they are not satisfied for any reason, doesn't have to be any reason, the wood trim is crooked and I can't live with myself because I'm looking at the wood trim and it's crooked, right? For whatever reason, they can back out with no recourse. They get the deposit back within the window, okay? It doesn't mean that the buyer has the right to negotiate after home inspection. Because here's what happens on the contract law, right? Is that if you're negotiating, when you negotiate, you terminate an agreement and you start a new one. So it doesn't give you the right to terminate this and start a new one. You can negotiate and the seller can say no and then move on to somebody else, right? So understand that it's either you have the right to move forward or back out. That's what this clause gives you. Doesn't give you the right to renegotiate it. So if you are going to renegotiate it, be tactful. Talk to me. We'll have some other training classes on how to negotiate, how to do that without killing the deal and putting your buyers in jeopardy. Okay. We'll get into that. Lead paint. Now, this disclosure, this piece here, read it, go through it. It gives and under the federal law, the buyer does have the right to perform a lead paint inspection. It's at their cost. They'll have 10 days to do it if they choose to do a lead paint inspection. And this clause also, educates them on some other things they should be mindful of. Now, remember, if you are buying a property that has a well, the bank is going to require a water test. So make sure you have enough time added here that you're doing the water test, and let the home inspector know that you are doing a water quality test, because if not, that can drag on the inspection period. So you really want to make sure you do it in time. Now, if by chance you do an inspection and you need an extra few days to get the results back, maybe you're doing radon and you're at the tail end of that inspection window, you always want to ask for an extension of the inspection time. Okay, you don't want to just have a conversation with the listing agent and say, oh, hey, is it okay? Yeah, verbal means nothing. All right, so you have to have it in writing. So even if it's 1 day extension, you want to ask for that 1 day extension and make sure you get it, because if you don't, and then there's a problem and you're trying to negotiate it, you can't. All right, so number 7, representations and acknowledgement. This is a key piece of this contract to the offer. It states here to the consumer that the agent has fully represented themselves. They gave you the agency disclosure. They gave them the facts for consumer form and the lead paint form if it was required, if the home was built before 1978. It gets into all of that. It also gets into that, that we are not providing legal advice, and that the consumer should, if, through their due diligence, if there's certain information that's important to them, if they need to know about the zoning or certain things that they want to do to the property, that it's really up to them to go dig for that information, and it's not up to the agent to do so, okay? And they're also acknowledging that they're making this offer on their own free will. They're not being coerced to do so. They're not being influenced to do so. They're doing everything, on their own accord. So they will, on the bottom here, they're going to state none, stating that, yes, that, I'm making this offer on my own free will. I'm not being forced to do that. But it states right there that you've given them certain disclosure forms. So you want to make sure that you have that agency, that lead, and that fact for consumer home inspection report, because they're attesting to it right there. Okay. So you have that. All right. So under number 8, buyer defaults, right? So here, now this is where you have to be careful, because different contracts have different verbiage here. Now this one here just states that, listen, all monies that were given as part of a deposit, right, will be given to the seller if the buyer defaults as liquidated damages. Great. However, remember that escrow agent piece on the top there? We can only release the money if both parties consent. So even though it says this here, it says that, yeah, the seller can go after the deposit. It's only going to get released if both parties agree. Okay. Now, if there's a breach of contract before the purchase and sales, the seller's only going to go after the initial deposit. If both deposits were done, then the seller can go after both. So, understand that, be careful with that, explain it to your buyer, understand how that works. But that's what we have here in the event of a buyer breach of contract. Now, number 9, additional terms. Now here, this is where we get creative sometimes with the offer. And I will caution you, right? If the offer is very complicated, as far as certain things they want included in the sale, or if it's contingent on multiple properties being sold or what have you, you may not have enough space here. You want to add an addendum, but furthermore, you may want to have an attorney review that addendum or that language before you put it in. Remember, we're not attorneys, right? If it's something that's pretty much, if it's clean, simple and clean that we can do it. But if it's something super complicated, you want to have an attorney review that language before you submit the offer. Now, I'll give you this advice here. This is what I add in this spot right here. The first thing I write is offer is subject to a mutually satisfactory purchase and sales agreement. It's the first thing I write in there. Now, the reason why I do this is because this offer makes reference to there's going to be a purchase and sales. Okay. Now, most attorneys use it's a generic P&S. Okay. It's standard. However, depending on what county you're in, those attorneys, like the buyer attorney, may want to add extra language or extra addendums to the P&S. Well, if you don't have that language in there, subject to a mutually satisfactory purchase and sales, that attorney can get pushback. And now your buyer is kind of being bullied into signing a document that may not be in their best interest. So by having that language in there and having the seller sign off, then that means that when we get to P&S, everyone has to play nice, right? Everyone has to agree and move forward. If we don't agree, then the buyer has a right to back out and get the deposit back, and we don't even move over. We don't move into P&S, right? So I add that language in there. In this spot here as well, you'll also add about closing cost credit. All right. So again, if this is simple, and you're saying, look, we want $5,000 back for closing costs, you can add that language in there. What I do is I put, subject to offer subject to a mutually satisfactory purchase and sales agreement. And I put also subject to addendum A, right? So I add a separate document where I put anything else I'm going to add. If I'm going to do, closing cost rollback, I'm going to do that. If I'm going to do Title V language, I'm going to add it there. If I'm doing appraisal language, any of that stuff, anything extra, if the lawnmower is going to be part of the deal, I'm going to add all that stuff in there. Okay. I'll do another video just on contingencies, but that you can add under the addendum. So I'll give you some language on it. Again, check with your broker and make sure you're okay. I know I'm the broker for EXP. EXP has not approved the addendums that I have, the clauses that I have in there. So therefore, I can't really promote and say, go use it. But if you use it, it's on your own. I'm okay with it. I've been using it for years and I'm fine with it. But really, it's at your own risk. So I'm going to give you that disclaimer that's out there. So I'll have another video on on those contingencies coming up that you can add to your offer to purchase. Now, the last thing you have here is signatures, right? So the buyer's going to sign off, all the buyers. You're going to present it to the seller, and then the seller's going to either accept, reject, or counter. Right? And whatever it is they're going to do, well, they're going to choose the appropriate boxes here. So if there's a counter, they're going to choose counter, sign, and then give you what that counter is. Is it a sale price? Is it whatever it is? And then go back and forth. And if it's something clean, then at that point, your buyer can, accept and move forward, or your buyer can recounter. So understand that can go on forever. Everyone has the right to counter. You can counter higher or lower. There is no, rule of thumb as far as how to counter. Just understand that once you counter, you terminate the original agreement. So let's say I present this to my buyer at $500,000 and that seller says, no, I want, a highest and best offer. Well, that's a counter. So you're killing my $500,000. So the buyer can say, well, listen, we're walking, we're not moving forward. And then the seller says, okay, we'll take your $500,000. Well, guess what? My buyer's not obligated to move forward because the seller countered our original offer. Okay. And it could be as simple as a date. It doesn't have to be dollar amount. It could be one date. If I say, look, I want to close in 30 days and the seller says, I want to close in 29 days, that's a counter. Therefore, our original offer terminates. We have an offer for 29 days. My buyer doesn't have to move forward with that 29 days. They can say, nope, I'm walking, and that's it. And if the buyer said, and the seller says, yeah, I'll take the 30 days, the buyer is under no obligation to move forward with that deal because the seller countered the original offer. So understand that, because we get a lot of agents that try to be superheroes, right? Or like a few good men, they think they're attorneys and they're going nuts and they start negotiating on their client's behalf without their client's consent. That's a problem. Okay. And we'll get into that, on another video, different class. We'll talk about, negotiation strategies, and understanding what your role, what your position is when you are negotiating on behalf of someone else. Okay. Well, there you have it, folks. This is how to fill out an offer here. If you have questions, please let me know. I will certainly get back to you and help you with that. Hopefully this kind of shed some light as far as how to fill out these forms, and answered a lot of questions. So thank you. Happy selling. And until next time.